Let the record show that on this day, March 23rd, 1982, at 3:20 p.m., docket 81-53-21 began. The case in progress is Enmund versus Florida, questioning whether or not Mr. Enmund's sentencing of the death penalty on 2 accounts of first-degree murder and 1 account of robbery violates the 8th Amendment of cruel and unusual punishment. Petitioner, your opening statement.
Mr. Chief Justice, and may it please the court, the petitioner, Earl Enmund, who has been sentenced to death by the state of Florida for 2 counts of homicide, maintains that his sentence was a violation of the rights granted to him under the 8th Amendment. Yes, our client is guilty of aiding and abetting the Armstrongs in the crime of robbery that has been confirmed by both Mr. Enmund and the Court of Florida. But Mr. Enmund is adamant that he did not kill, attempt to kill, or intend to kill the victims. The petition has gathered here to declare that the ruling of the Florida court opposes the 8th Amendment, which guarantees that upon no citizen shall cruel and unusual punishments be inflicted. Mr. Enmund did not kill anyone, which was confirmed by the lower court, yet they found his actions to be punishable by death. To summarize the events of the crime, the petitioner was a getaway driver for the Armstrongs in the premeditated robbery of Mr. and Mrs. Kersey. While Enmund waited in the car, the Armstrongs asked the Kerseys for water. Sampson then grabbed Mr. Kersey and held him at gunpoint. Mrs. Kersey heard her husband cry out and rushed to his aid, grabbing a gun. She then proceeded to fire at Jeanette Armstrong. The shot prompted Sampson Armstrong to kill the Kerseys in cold blood. When the Armstrongs returned, Enmund sped away with them. The robbery was premeditated, but the murders were not. Nor did our client have any part in those deaths. He maintains that he never left the vehicle during the altercation, nor did he have any knowledge of the homicides committed by his partners. Thank you, Your Honor.
Respondent, your opening statement.
Your Honor, if it pleases the court, the real issue in this case is whether a state legislature could rationally conclude that the death sentence should be administered to a defendant convicted of first-degree murder based on his extensive participation in armed robbery resulting in death, which he planned, provided accomplices and weapons for, participated in, and helped to cover up.
Petitioner, you may call your first witness.
Your Honor, I call Earl Enmund to the stand. Please place your right hand on the Bible. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Aye.
Okay, you can sit down. Did you rob Mr. and Mrs. Kersey?
No, sir.
Did you plan on murdering Mr. and Mrs. Kersey?
No, sir.
Were you aware of any murder premeditation on any party's part, whether it being Mr. and Mrs. Armstrong or yourself?
No, sir.
Did you ever exit your car that night?
No, sir. I had no reason to.
If you had not gone with Mr. and Mrs. Armstrong that night, do you think that the murder would have still taken place?
I don't see why not. They could have called anybody else. They could have even called a cab.
What did you do once you heard of the incident that had taken place?
I was appalled. My hands were shaking. I didn't know what to do. I didn't know any of this was going to happen.
Just to reiterate for the court, you, Mr. Edmund, did not rob Mr. and Mrs. Kersey, nor did you murder them. That is correct.
That is correct, sir.
In your opinion, do you deserve the death penalty?
No, sir.
No further questions, Your Honor. Did you know who Mr. and Miss Kersey were before the robbery?
Yes.
Did you know that the robbery could potentially turn violent?
It was supposed to be very cut and dry. That was Sampson.
Describe your relations with the Armstrongs.
Very distant. We didn't know each other for long, barely ever talked.
Okay. Were you armed at the time of the robbery?
No, sir.
Please reiterate what happened after the crimes were committed. What were your interactions with the deceased couple and the guns?
Once I found out what happened, everything just sped up from there. I don't recall most of it. It feels like a blur, really. I don't remember having any interactions with the deceased couple. No guns, definitely.
Why do you believe that you are above Florida constructive malice doctrine?
I don't believe I'm above anything, sir, but I do know that this is a strict violation of my Eighth Amendment rights, if I do say so myself.
No further questions.
Respondent, you may call your first witness to the stand.
Place your hand on the Bible. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Did you and Enmund try to dispose of the guns after the murder?
Yes.
Did the getaway car belong to you?
Yes.
Did you in any way, shape, or form attempt to assist the robbery of the couple?
No.
Did you know that there had been a robbery?
Yes.
Did you know that there had been murder?
No.
No further questions, Your Honor.
Ms. Shaw, what is your relation to the petitioner?
He knows my daughter,
And that's all?
I guess.
Did you contribute to a plan to dispose of the guns used in the murders?
Yes.
Was the .22 caliber used for the murders, one of the murders, your gun?
Yes.
So admitting this, were you involved in any aspect of the robbery scheme and murder of Mr. and Mrs. Kersey?
No.
Thank you.
Petitioner, your witness.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Now, Mr. Armstrong, what was your relationship with the petitioner?
I was a friend of Earl's.
What was your role in the crime?
I have pleaded guilty for murder.
What was the original plan?
The original plan was to rob the household and get away with Edmund as our getaway driver.
So the robbery was premeditated.
Yes, sir.
Were the murders?
No, sir.
What prompted you to kill the Kerseys?
Well, Mrs. Kersey shot my wife in the arm, and I wasn't having any of that.
Did Enmund leave the car?
Not to my knowledge.
So you can confirm that Enmund was nowhere near the scene of the crime.
Yes, sir. He was nowhere near.
No further questions, Your Honor.
Okay. Petitioner, your witness.
Place your hand on the Bible. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Where were you that morning of the shootings?
At my house.
Could you see the car that was parked 200 yards away from the scene?
Yes, it was very small.
Could you see inside the car?
Yes.
Did you see a male in the car?
Yes.
How many people did you see in the car?
3. There were 3 people in the car.
At what point in time?
Um,
Before or after you heard the shots?
After, a little bit after, there were 2 people came out the house.
Did you see anyone in the car during the shootings?
There was one person in the car.
What did he or she look like?
That man there.
Did the man in the car ever exit the car and approach the scene?
No.
So the person in the car was in the car the entire time?
Yes.
Thank you.
Respondent, you may call your witness to the stand.
The response calls eyewitness Willie Lee to the stand.
Place your right hand on the Bible. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Maybe take it around.
Let the record show that your involvement with this case is that you saw Edmund in the car the day of the murder, yes?
Yes.
What was Edmund's position in the car before and after the crimes took place?
Before the crime took place, Edmund was in the passenger seat of the car. After the crime took place, he was driving the car at a very reckless speed.
Interesting. So you could say that Edmund possibly had gotten out of the car at some point.
I would say so.
So it's possible that he himself could have gotten out of the car and committed the crimes.
Seems so.
Thank you. No further questions.
Petitioner, your closing statement.
Earl Edmund is petitioning the court for unproportionately sentencing him to the death penalty. The sentencing of the death penalty in Mr. Edmund's case is unconstitutional in that it violates the Eighth Amendment. On that morning in 1975, Sampson and Jeanette Armstrong approached Thomas and Eunice Kersey's home one morning in an attempt to rob them. Mr. Edmund was a part of the robbery scheme in that he was the getaway driver. What was not a part of the plan, however, was Mrs. Kersey pulling out a gun and Sampson Armstrong's spontaneous decision to shoot and kill both Mr. and Mrs. Kersey. Edmund had no prior knowledge the murders were going to take place, nor could he have participated or prevented them due to the fact that he was in an automobile 200 yards away from the scene. Considering the fact that Mr. Edmund had no intent to kill, nor did he have knowledge of Mr. Armstrong's capability to kill, the death penalty for petitioner in this case is excessive. We suggest life in prison without the possibility of parole for 25 years for his involvement in the robbery.
Respondent, your closing statement.
Earl Edmund has been sentenced to the death penalty for his involvement with the murders of Mr. and Miss Kersey. Edmund had previous relations with the Kerseys and played a key role, as in he offered the Kerseys up to the Armstrongs and was the getaway driver. This was a premeditated robbery, but the murders were said to be spontaneous. Earl Edmund is pleading the eighth, saying he did not commit the murders, therefore he should not be sentenced to the death penalty for them. Something to notice is although Mr. Edmund says he did not commit the murders, his involvement in this fiasco is something to take note of. Earl orchestrated this robbery, provided the elderly couple was the getaway driver, and assisted in getting rid of the evidence. Thank you.
After hearing this trial, there are two opposing views of which Mr. Enmund's Eighth Amendment rights have been violated, and that the death sentence was too harsh of a sentence, and the other, this case needs to be remanded for another sentence hearing. What does the jury vote? You live! Oh God, that hurt. Did you rip it off? Yeah. Put that on the video. In the court, there was a 5-4 majority to reverse what the lower court decision was, to give Mr. Enmund the death penalty. The Supreme Court held that imposing the death penalty on someone who aided and abetted but did not kill himself kill, or attempt to kill, or intend to kill violated the 8th and 14th Amendments. It is unlikely that the death penalty could deter someone who did not intend to kill or attempt to kill, and putting someone to the death for 2 killings they did not commit is disproportionate retribution.
You might need to repeat that.
1, 2, 3.
Oh my gosh, Jesus! I've ripped it off 3 times and I've never done it that fast.
I haven't done that fast either.
No laser hair removal needed.
Ah!
Like this.
Ripped it off
And that's a wet